Everybody,
Good morning.
call the meeting of the Ethics Commission to order. I have a couple of statements that I have to read before we get into the agenda that you've been sent prior to the meeting. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive teleconference meeting was held on May 2nd, 2013 to review matters that are by statute 65 PA CS 1108 AC confidential, including the review and consideration of applications for 90-day extensions of investigations filed, to review the pending legislation. An executive teleconference meeting was held on June 12, 2013 to review matters that are by statute 65 PA CS 1108 AC confidential, including to receive legal advice and discuss possible settlement of litigation and/or complaints in connection with the OOR case, Haverstick via versus State Ethics Commission. An executive meeting was held on July 9, 2013 to review matters that are by statute 65 BA CS 1108 AC confidential, including the review of completed investigations for purposes of using or issuing final adjudications, the consideration of the assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and the review of pending legislation. This is my opening statement for this morning's meeting. Pursuant to the Public Official and Employee Ethics Act, Public Employees Ethics Law, Act 170 of 1978, as amended by Act 9 of 1989, of June 26, 1989, and as amended by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individuals subject to the provisions of this act and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. Thank you. Let's go to the agenda for today's meeting. Item 1 is approval of the January 28 minutes. Do I have a motion to accept those?
So moved.
Moved, is there a second? Moved is second. Any questions, comments?
I would abstain, I was not present here.
Please note, Judge Lewis will abstain, she was not present. Any other questions or comments? All those in favor, please say aye. Any opposed? Minutes approved, with the abstention of Judge Lewis. Second item is minutes of the March 8th public meeting. Do I have a motion to accept these minutes?
So moved.
Moved in, is there a second? Second. Any questions, comments?
Again, I would abstain, I was not on the commission at that time.
Thank you. Please note, Judge Lewis has abstained, as she was not in attendance. Any other questions or comments? Okay, all those in favor say aye.
Aye.
Any opposed? Minutes have been approved with the abstention of Judge Lewis. Okay, item 3, lobbying, civil penalty orders, consent agreement. Commissioner Caldwell has been assigned.
Thank you, Mr. Chairman. There are 9 administrative penalty cases with proposed consent agreements for our consideration. The following 9 respondents are principals that failed to timely file a quarterly expense report for the third quarter of 2012 in their capacities as registered principals. 1, Matrix Development Group, Pennsylvania National Guard Associations, Synergy Real Estate Corporation, the American Chemistry Council, Ahold USA, Clean Water Action, Astrum Solar Inc., Ceasefire PA, and National Safety Compliance. In each case, the parties are in agreement that the respondents' transgressions of the lobbying disclosure law were negligent. Except for National Safety Compliance, the respondents have already filed their delinquent expense reports. National Safety Compliance should be ordered to file its third quarter 2012 expense report with the Department of State within 30 days of issuance of the Commission's order. The respondents are in the process of paying the agreed upon penalties. Those who have not yet paid should be ordered to pay their penalties within 30 days of issuance of the Commission's orders. Astrum Solar Inc. and National Safety Compliance have agreed that for 3 years from the date of issuance of the Commission's orders, they will refrain from registering as a principal with the Department of State and will refrain from any and all lobbying activities in Pennsylvania. The parties are free to contract to such terms in a consent agreement. Mr. Chairman, based upon my review of the facts, I'm of the opinion that the consent agreements are proper dispositions for the respective cases, and I would like to make the following motion. Therefore, I move that this commission approve the consent agreement submitted by each of the following respondents and the investigative division, and impose the following administrative penalties for the respondents' delinquent expense reports for the third quarter of 2012. As to number 1, as to Matrix Development Group, Pennsylvania National Guard Associations, American Chemistry Council, Ahold USA, Clean Water Action, and Ceasefire PA, 1 administrative penalty per respondent in the amount of $3,290 each. Number 2, as to Synergy Real Estate Corporation, 1 administrative penalty in the amount of $3,222. I'm sorry, $3,220. Number 3, as to Astrum Solar Inc. and National Safety Compliance, 1 administrative penalty per respondent in the amount of $750 each. I further move that 1 National Safety Compliance be ordered to file its third quarter 2012 expense report with the Department of State within 30 days of issuance of the Commission's order. And number 2, Astrum Solar Inc. and National Safety Compliance be ordered to fulfill their agreements that for 3 years from the date of issuance of the Commission's orders, they will refrain from registering as a principal with the Department of State and will refrain from any and all lobbying activities in Pennsylvania. Mr. Chairman, I move that the Commission approve these administrative penalties.
Thank you, Commissioner Caldwell. Is there a second?
Second.
Okay, it's been moved in second. Any questions or comments? I have a question. Okay, Mr. Mark.
Just a question about all of them. It appears that the timing from the State Department when we're getting these cases is getting slightly better. Are they working on that at all?
They,
we've had discussions. Brian had a meeting with Jonathan Marks, the director, and they have had some turnover in staff, they're short-staffed, and they're still have problems. They last,
Doesn't the computer automatically tickle these files, that if it hasn't been,
go ahead, Brian,
you know, we're a year later and we're talking about something that,
Commissioner Corrigan and the rest of the commissioners, this has been a problem that we tried to work with the Department of State since the lobbying law was enacted. My understanding after numerous meetings with both the chief of the finance campaign and lobbying disclosure section of the Department of State, as well as her superiors, have always said the same explanation, that even though the deadlines are statutory, for some reason they cannot coordinate the computer system generating who has not filed and which forms are delinquent. In fact, this last round, we just received, and forgive me for the date, but I believe we just received on July, within the last 2 weeks, we just received the first quarter delinquents. That's 90 days after the close of the quarter, and it's 60 days after the filing deadline to file. We both sent correspondence, and I also spoke with, as Mr. Cruz has said, Mr. Marks over there, the Department of State, and we expressed our concern in regards to this. There's also a Senate bill that's pending that would require the forms to be filed electronically, and it also has to be posted within 7 days. We expressed concern that the lag time between the end of the quarter and when the reports are being generated for our agency to be able to send out warning notices is unacceptable. The Department of State acknowledged that there was a lag time, however, they sua sponte came up with this additional 60-day time period that they had to hold off before they could generate the reports for lobbyist verification. That's not in the law, and we expressed that to them, and our position is that the quarter ends on a certain date, there's a 30-day period to file the reports, and on day 31, that report should be generated and sent to us. We don't have access to that system, the State Department system. We've requested multiple times to be sent that report on that first day after the reports are due. The Department of State has assured us that they will send it within 30 days. So we're actually receiving the report 60 days after the close of the quarter. Now, I am proud to say that our staff received the Department of State's list at 3:30 on a Wednesday in the afternoon, and we had all the warning notices mailed out Friday morning at 9 o'clock in the morning. So we had the list for less than 72 hours, even less than 48 hours, and we were able to get those warning letters out. But to address the Commissioner's concern, there is still a lag time that we believe is not appropriate, but we're trying to work as close as we can in cooperation with the Department of State to close that.
okay, thanks, Brian.
we also, Robin and I met with the lobbyists, what firm are they with?
Greenland.
With Greenlee. The lobbyists were very concerned that documentation that they're entering into the Department of State system isn't being.
Isn't showing up.
Isn't showing up.
Is it sitting in a cache somewhere and it's just not updating on the screen, or?
What happened, apparently they rolled out a new system at the Department of State, and we're trying to make improvements to it, but there are problems with it. And our understanding is that the Department of State was using different firms to try it out and give them feedback, and these particular lobbyists were among those. And they were just concerned that from an enforcement angle, the commission needs to understand there are problems. The one lobbyist was saying that when she would amend her registration statement to add principals, just wouldn't show up. And eventually, months later, wasn't it, they got it to show up, but she was concerned that during that whole time, it looked like she wasn't representing these people, or that she hadn't registered to show that.
I had a question, I just briefly added, there's about $30,000 there. Where does that go? Is there any chance we can get that?
As now it all goes back to the general fund, we don't get any of that.
Just the general fund, it doesn't go back?
Well, actually, I think it goes back to the Department of State.
Does it go back to the Department of State?
Yes.
so they could get their computers updated.
They say that they're woefully under budget as well, and that's part of the problem why they're so late in getting us the information.
Okay. Let me see, we have a motion and a second. Any more questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion approved. Thank you, Commissioner Colafella. Next item on the agenda is Raphael. Commissioner Nick, I think you've been assigned that case.
Thank you, Mr. Chairman. The facts pertaining to this advisory request are as follows. The requester is David J. Raphael, Esquire, who is Chief Counsel of the Pennsylvania Department of Environmental Protection. Mr. Raphael has requested an advisory on behalf of John W. Ryder, who is currently employed with the Pennsylvania Department of Environmental Protection as the Director of the Bureau of District Oil and Gas Operations, which I shall refer to as the Bureau. Mr. Ryder became the Director of the Bureau effective April 7, 2012. Mr. Ryder performed professional managerial work directing the activities of professional, administrative, and technical staff engaged in a variety of duties involving the permitting, inspection, enforcement, and compliance activities of the statewide oil and gas program. While Mr. Ryder does not personally perform well site inspections, he directs the activities of other Bureau employees engaged in permitting and inspecting well operations and enforcing oil and gas laws, regulations, and policies. A finding by Mr. Ryder that a well operation is not in compliance with law or regulation could lead to enforcement action against the responsible operators, which in turn could result in obligations by the operators to take corrective action and pay financial penalties. In a private capacity, Mr. Ryder is one of 3 protectors of a family trust, which I shall refer to as the trust. The trust includes rental and royalty interest in gas leases on family-owned property, which I shall refer to as the trust property in Lycoming County, Pennsylvania. As a protector of the trust, Mr. Ryder is a beneficiary of the trust and has some power to direct the trustee in the handling of trust assets. The gas leases on the trust property are held by a single gas company, which I shall refer to as the gas company. No drilling activity is currently taking place on the trust property, and no royalties are currently being paid or accrued. If oil or gas wells would be drilled on the trust property, the drilling and related activities would be subject to the Bureau's regulatory oversight. Since Mr. Ryder learned of his appointment as Director of the Bureau, he has had no involvement in overseeing the Bureau's regulatory activities with respect to the operations of the gas company, and has had no input into his subordinates' decisions regarding regulatory oversight of the gas company's activities. Mr. Raphael asked whether the Ethics Act would impose any prohibitions or restrictions upon Mr. Ryder with regard to performing the duties of his position as a Director of the Bureau, including management duties, as a result of his role in his private capacity as a protector of the trust. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
I don't know, is there any interested parties that want to speak on that behalf? Chair notes none, please continue.
Thank you. Mr. Chairman, I reviewed the facts and relevant statutory provisions with counsel. It is my belief that in his capacity as the Director of the Bureau, Mr. Ryder is a public employee subject to the Ethics Act and the regulations of this commission. It is my view that as the Director of the Bureau, Mr. Ryder generally would have a conflict of interest under Section 1103A of the Ethics Act in matters that would financially impact him, a member of his immediate family, or a business with which he or a member of his immediate family is associated. In the Kistler case, the Pennsylvania Supreme Court held that in order to violate Section 1103A of the Ethics Act, a public official, public employee, quote, "must be consciously aware of a private pecuniary benefit for himself, his family, or his business, and then must take action in the form of one or more specific steps to attain that benefit," end quote. Based upon Kistler, the existence of a violation of section 1103 would depend upon the circumstances in a given case. In applying the Kistler decision to the submitted facts, Mr. Ryder would have a conflict of interest and would violate section 1103 of the Ethics Act in performing the duties of his position as the director of the Bureau, including but not limited to management duties, to the extent that, one, he would be consciously aware of a private pecuniary benefit for himself, a member of his immediate family, or a business with which he or a member of his immediate family is associated, and two, his actions would constitute one or more specific steps to attain that benefit. In each instance of a conflict of interest, Mr. Ryder would be required to abstain from participation. Given my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. In the capacity as the Director of the Bureau of District Oil and Gas Operations within the Pennsylvania Department of Environmental Protection, John W. Ryder would be considered a public employee subject to the provisions of the Ethics Act and the regulations of the State Ethics Commission. As the Director of the Bureau, Mr. Ryder generally would have a conflict of interest under section 1103A of the Ethics Act in matters that would financially impact him, a member of his immediate family, or a business with which he or a member of his immediate family is associated. Mr. Ryder would have a conflict of interest and would violate section 1103A of the Ethics Act in performing the duties of his position as the Director of the Bureau, including but not limited to management duties, to the extent that, one, he would be consciously aware of a private pecuniary benefit for himself, a member of his immediate family, or a business with which he is a member of, or a member of his immediate family is associated. And two, his action would constitute one or more specific steps to attain that benefit. In each instance of a conflict of interest, Mr. Ryder would be required to abstain from participation.
Thank you, Commissioner Nick. Is there a second?
I'll second.
Second by Commissioner Caldwell. Any questions, comments? Hearing none, all those in favor, please say aye.
Aye.
Any opposed? Motion is adopted. Thank you, Commissioner Nick. Next item on the agenda, item 5, is the shrimp appeal of advice of counsel. Commissioner Corrigan has been assigned this case. Commissioner Corrigan?
This is an appeal of an advice of counsel, and the appellant is attorney Amy R. Schremp. The advice of counsel is 13-524, which was issued to her on behalf of a Robert W. Similo on April 25th, 2013. Mr. Similo is a former member and chairman of the Elizabeth Township Sanitary Authority, which shall be referred to as the Authority. His most recent term as an Authority board member ended on December 31st, 2012, and he was not reappointed. The Authority would now like to hire Mr. Similo as a consultant to the Authority to assist the new Authority chairman with certain ongoing projects in which Mr. Similo was previously directly involved. The proposed services would be provided pursuant to an agreement between the Authority and a corporation named S&S Scientific, which is located at Mr. Similo's address. Ms. Schremp requested guidance as to whether the Ethics Act would prohibit Mr. Similo from acting as a consultant to the Authority. Advice of Counsel 13-524 determined that in the former capacity as a member and chairman of the Authority Board, Mr. Similo would be considered a public official subject to the Ethics Act and the regulations of this commission. The advice determined that upon termination of service as a member of the Authority Board, Mr. Similo became a former public official subject to section 1303G of the Act, the Ethics Act. The advice further determined that Mr. Similo's former governmental body is the authority in its entirety. The advice set forth the restrictions of section 1103G of the Ethics Act as applicable to Mr. Similo. The advice concluded that during the first year following termination of Mr. Similo's service as an authority board member, section 1103G of the Ethics Act would prohibit Mr. Similo from entering into a consulting contract with the authority and/or providing consultant services to the authority with promised or actual compensation, as such activities would constitute prohibited representation of persons before the authority. By letter dated April 29th, 2013, Ms. Schremp appealed this advice of counsel. Ms. Schremp contends that in providing the proposed consulting services to the authority, Mr. Similo would not be representing any person before the authority board, but would be acting on behalf of and working directly with the authority board. Ms. Schremp further contends that none of Mr. Similo's proposed actions would fit the definition of the term represent. Mr. Chair, we would suggest now at this point it would be appropriate for any interested parties to speak up on this matter.
I see that anyone interested in speaking on her behalf? I see none. Please proceed.
Having reviewed the facts and the relevant statutory provisions, I would note that for the first year following termination of service as an authority board member, section 1103G of the Ethics Act would apply to Mr. Similo and restrict representation of a person before the authority with promised or actual compensation. I would further note that the Ethics Act broadly defines the term represent to prohibit acting on behalf of any person in any activity, and defines the term person to include corporations and individuals. And this commission has previously determined that the term person includes the former public official or public employee himself. This commission has also previously held that a former public official and former public employee may not enter into a consulting contract with his former governmental body during the first year following termination of public service, because in providing such consulting services, the former public official or former public employee would be acting on behalf of a person, whether a business or himself, before his former governmental body in contravention of section 1103G of the Ethics Act. It is my view that during the first year following termination of his service as an authority board member, section 1103G of the Ethics Act would prohibit Mr. Similo from entering into a consulting contract with the authority and/or providing consultant services to the authority with promised or actual compensation, as such activities would constitute prohibited representation of persons, specifically S&S Scientific and himself, before the authority. Based on the foregoing, I would like to move that the holding of this commission in this matter be as follows. In the former capacity as a member and chairman of the authority board, Mr. Similo would be considered a public official, subject to the Ethics Act and the regulations of this commission. Upon termination of service as an authority board member, Mr. Similo became a former public official, subject to section 1103G of the Ethics Act. The former governmental body is the authority in its entirety. Under the submitted facts, during the first year following termination of his service as an authority board member, section 1103G of the Ethics Act would prohibit Mr. Similo from entering into a consulting contract with the authority and/or providing consultant services to the authority with promised or actual compensation, as such activities would constitute prohibited representation of persons, specifically S&S Scientific Corporation or himself, before the authority. The appeal is denied. Advice of counsel 13-524 should be affirmed.
Okay, you heard the motion from Commissioner Corrigan. Is there a second?
Second.
Commissioner Caldwell. Any questions, comments? Commissioner Lewis, understand what
Yes.
happened, what we're doing there?
Absolutely.
Okay, good. Any other comments or questions? All those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Thank you, Commissioner Corrigan. Okay, next item on the agenda is civil penalties for consent. Commissioner Nick?
There are 5 civil penalty cases with proposed consent agreements that are now before this commission for decision. These cases involve respondents Brian Vanderson, Robert Montemuro, Robert Listenby, John Johnstone, and John M. Gallick. The parties have submitted consent agreement. Each consent agreement proposes that the commission find that the respective respondent failed to timely file a statement of financial interest for calendar year 2010 and impose 1 civil penalty in the amount of $150. With the exception of respondent Van Dusen, each of the respondents has paid the recommended civil penalty. Each of the respondents has filed the delinquent form. Based upon a review of the facts, I am of the opinion that these consent agreements are consistent with commission precedent and are proper dispositions for these cases. It is my opinion that the commission should order respondent Van Dusen to pay the recommended civil penalty agreed to by the parties per the consent agreement. Based upon this analysis, I would move that this commission approve the consent agreements submitted by each of the following respondents and the investigative division, imposing civil penalties for failure to timely file statements of financial interest for calendar 2010 as follows. Brian Vanderson, $150. Robert Montemuro, $150. Robert Listenby, $150. John Johnstone, $150. And John M. Gallick, $150. Further, respondent Van Dusen shall be ordered to pay the recommended civil penalty agreed to by the parties per the consent agreement within 30 days of the issuance of the commission's order.
Thank you. Do I hear a second?
Second.
Okay, any questions, comments on these civil penalties? Yes.
Yes, granted, these civil penalties are not large, but I have 2 questions. The first one's on Robert Listenby. You know, he's a member of the Pennsylvania Commission on Crime and Delinquency, Juvenile Justice and Delinquency Prevention Committee, and he's also a lawyer. And he receives 1 letter telling him he can cure this without getting any civil penalties, and he ignores that. Shame on him. Then he gets a certified letter from us, and again, he ignores it and throws it away. And we're, you know, as a lawyer, he ought to know better than that. I don't understand why we're only fining him the $150. I know it's not much, but why not $250?
That's what was negotiated. I agree, it probably should have been more, but in the negotiations, that's what we threw out there, and that's what he jumped at.
Oh, but he did.
Did he give any reasons for why he didn't comply?
I didn't speak to Mr. Listenby. Brian, I don't know if you negotiated that.
I did not negotiate that one, but I am familiar with Mr. Listenby. He indicated that he simply forgot and that his busy schedule precluded him from filling the form out timely. I believe Attorney Petsu negotiated the settlement in this one, since it was in accord with other individuals who had failed to file. We didn't want to single him out and be unfair simply because he is an attorney. We treated him fairly and gave him I guess, a consistent offer of what we offered other people.
Okay.
Another question. I noticed, do we have a problem with constables?
Absolutely.
Same problem with the Supreme Court having everyone.
Yeah, they just don't, they ignore notices after notices. We reached out to their board, they try to get the information to these guys to let them know that they should file, and when the forms are given, they ignore it. And a lot of times we have a very difficult time tracking them down to get them served the second notice letters. And that was part of the thing with the posting issue, why we would like to push forward so that our guys aren't sitting out there for hours at a time waiting for these guys to come
Oh,
in.
you mean we're sitting out there for a constable for $150?
That's what I was just gonna say.
Is that what we're doing, to make personal service?
That's correct, and sometimes actually, we're trying just to serve the second notice. So if they comply, there's no penalty. Why we were pushing or requesting the commission to authorize us to serve these notices by posting, to really save the agency a tremendous amount of money and also manpower times.
Yeah, remember that, I brought that up yesterday. I think we should revisit that and maybe at our next meeting get some report back, because I agree with Commissioner Corrigan. We got some, guy out there sitting around waiting to serve this guy, and then we fine him $150. It doesn't, it's not even good business sense.
Right.
Along commission business. Are we all in agreement that we ought to take a look at that?
Absolutely.
Okay, any other questions or comments? There's a motion and there's a second. All those in favor, please say aye.
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 Any opposed? Motion adopted. Thank you, Commissioner Nick. Okay, we haven't had a lot of these, but we have a gaming case. Shelley?
Excuse me,
Oops, excuse me.
Mr. Chair, there's the default civil penalty order number 7 on the agenda.
Oh, I'm sorry, I'm sorry. Civil penalties default. Roger, you have that too, I'm sorry.
You don't keep me lunch or busy, go ahead.
Mr. Chairman, there's one civil penalty default case that is now before the commission for decision. This case involves respondent Terrence Crumby, who failed to file a statement of financial interest for calendar year 2010. The respondent did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to the respondent, the commission should levy a maximum civil penalty of $250 for the delinquent statement of financial interest. It is my opinion that the commission should also order the respondent to file his delinquent statement of financial interest. There is nothing of record that would constitute a defense or excuse for his non-compliance. Based upon the analysis, I would like to make the following motion. I move that this commission levy a maximum civil penalty in a total amount of $250 against respondent Terrence Crumby for failing to file a statement of financial interest for calendar year 2010. Further, the respondent shall be ordered to file a statement of financial interest for calendar 2010 within 30 days of issuance of the commission's order.
Thank you. Is there a second?
Second.
Second by Commissioner Corrigan. Any questions, comments? If not, all those in favor say aye.
Aye.
Any opposed? Motion adopted. Thank you, Commissioner Nick. Okay, now we can go to item number 8, which is a gaming commission case. Shelley and Commissioner Corrigan, you're going to sign that case.
Yes, so relatively quick one here. The requester is a Kevin Shelley, and at the request of the Gaming Control Board, Office of Enforcement Counsel, Mr. Shelley has requested a determination from us pursuant to Section 1512 8.51 of the Pennsylvania Racehorse Development and Gaming Act, which shall be referred to as the Gaming Act. The issue before the commission is whether Mr. Shelley's service as a Towamencin Township District 1-2 Democratic Committee person would bring him within the definition of the terms party officer or public official as set forth in Section 1512B of the Gaming Act, and would therefore cause him to be subject to the restrictions of Section 1512A and A.1 and A.2 of the Gaming Act. We would note that Towamencin Township is located in Montgomery County, Pennsylvania, and Mr. Chair, this might be an appropriate time if anyone wanted to speak on his behalf.
Anyone want to speak on his behalf? Here, seeing nobody, please proceed.
There is no basis in the submitted facts to conclude that as a Towamencin Township District Democratic Committee person, Mr. Shelley would fall within the categories of party officers as set forth in the definition of that term. Specifically, there is no basis in the submitted facts to conclude that Mr. Shelley serves in any capacity with a national committee, state committee, executive committee of a state committee, or a city committee. As for the Montgomery County Democratic Committee, there is no indication in the submitted facts that Mr. Shelley is the county chairman, vice chairman, counsel, secretary, or treasurer of that committee. Additionally, none of the 5 numbered paragraphs in the Gaming Act's definition of public official would apply to Mr. Shelley. Paragraphs 1 and 2 of the definition would not apply to Mr. Shelley because they are particular public positions that Mr. Shelley does not hold. And paragraphs 3, 4, and 5 of the definition would not apply to Mr. Shelley because his position is not a county or municipal office or a position on a governmental body. Given this analysis, I would make the following motion that based upon the submitted facts, Mr. Shelley's service as a Toa-Menson Township District 1-2 Democratic Committee person would not bring him within the definitions of the terms party officer or public official as set forth in Section 1512B of the Gaming Act, and therefore would not cause him to be subject to the restrictions of Sections 1512A, A.1, and A.2 of the Gaming Act.
Thank you. Do I hear a second?
Second.
Any questions, comments? If not, all those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Thank you, Commissioner Corrigan. Okay, that brings us to item 9 under administrative matters. First item is the ratification of staff appointments and salary adjustments. What this is about is when we put the resignation and retirement of John Contino, after we went through the interview process and selected Rob Caruso as our executive director and promoted Brian Jasonson to executive deputy director. And remember, I called you about an increase for the staff, a 1-step increase. It's been recommended by council that we ratify these appointments and these increases as I just outlined. Gonna make myself clear? Okay, if that's the case and you understand what I've said, I need a motion to ratify action that we already took.
Could, Mr. Chairman, could the record also reflect that that would be their first increase in 3 years?
Yeah, I think for some that, right, okay.
I'll make the motion.
And the motion is to ratify the action that we've taken, and in some instances, the step increases. Okay. Commissioner Caldwell, been 3 years. Do you have that clear, or you understand? Everyone understand? All right, that motion by Commissioner Caldwell, is there a second? Commissioner Corrigan. Okay, any more questions or comments? Any additions, deletions? All right. All those in favor, please say aye.
Aye.
Any opposed? No. Okay. All we did there was ratify at a public meeting what we did previously.
Excuse me, Mr. Chairman, just so I'm clear for the record, that includes the appointment of Rob Caruso as Executive Director, Brian Jasonson as Deputy Executive Director and Director of Investigations effective May 6, 2013. The adjustments to the salaries of those positions, my position and everybody else?
Right.
Okay, thank you.
And then the step increases for the
Right.
rest.
Okay, thank you.
Okay, next is item 10, payment schedules. I'm not,
There are none.
there are none, okay. Okay, next is litigation update, Snyder et al. Rob, you want to take that?
Yes.
There's not
Commissioner,
much to report.
There isn't much, other than there was a motion for summary judgment, which was granted on February 20th by the U.S. Middle District, throwing out the case. Mr. Snyder, through his attorney Don Bailey, filed an appeal to that decision, and this could hang on for another year, is what we're being told.
Okay.
I'm not sure if Mr.
I don't
Bailey is
remember the
suspended
case.
now, or,
So we haven't heard from the Third Circuit.
no.
Okay, Rob, at this time, do you want to make your report before we do the budget resolution?
Sure. There's just a few items. I just wanted to update the commission that due to the budget problems that started in the latter part of 2010 and early 2011, we discontinued the practice of our SFI compliance and enforcement. We felt we didn't have the budget to send out the first and second notice letters, because we were, on state level alone, we were doing roughly 3,000 a year letters, first and second combined. So we discontinued that. With the passage and the approval of this budget, we believe we have the funds, and we've set funding aside, budgeted some money to renew the compliance efforts. First letters will be going out within the next week. We're starting first at state level, and then we will resume doing compliance reviews on the local level in the townships, boroughs, as we get investigations in those areas. Second thing is, Brian and I met with the new chief counsel for the Auditor General. We specifically discussed their elimination of their Office of Special Investigations. And they received complaints very similar to what we do. Some allege conflict of interest, some just allege, misuse of public monies, but with no gain to a public official. What they want to do, they're going to start referring all of their complaints that they get, they're going to refer them here. So they eliminated their budget and just passed some of the buck here. Now, I don't know how many complaints that will be a year, but they had, an office in Harrisburg, they had an office in Scranton, they had an office in Philly, they had investigators in Pittsburgh. So their investigative staff was probably 3 times as large as what we have. So I don't know what the volume of complaints that will be coming in here. A lot of them, I don't think we will have the jurisdiction, because they just allege misspent money rather than an actual conflict. But the complaints will come here, and we'll evaluate them, and we'll try to deal with them as best we can.
They're closing 4 offices, and we're going to get the cases that they...
The complaints will come in. A lot of them we probably won't open. We're doing a much better job reviewing things as they come in. I think we're taking a real close look at cases, and if it's anything that looks like it's going to be either a de minimis or really a close call in the use of office, we haven't been opening. We're trying to be pretty judicious in what we look at.
Do you have to report back to them?
No. No, they will refer them here. I don't think we really owe them anything. We look at them, we'll make the decision whether or not to open them.
Mark?
Well, on behalf of the citizens of the Commonwealth, they write in, what are we going to do with those things if we don't have jurisdiction? Are we going to refer them to anyone else? Or are we just going to say thank you, but it's not our bailiwick, and that really infuriates people?
No, what we had been doing for years, we had been sending out standard letters of either no jurisdiction or for whatever reason why we couldn't look at a case. What Brian and I have been doing the last several months is we're sending more detailed letters back to citizens saying the reason why we can't look at it and where, what if there's another state agency that might have jurisdiction over their matter. So we're trying to let them know that. Yes, ma'am.
Does a person know that their letter has been referred to the commission if they wrote directly to the Auditor General?
That I don't know if they will do that. They have what's called a tip line, an 800 number where people call in. I think when the calls come in, they will they're going to refer callers to our 800 line. So that, but I don't know if they will, if they get letters of complaint in, if they will advise those individuals they were referring them to us.
This has just started, just this fiscal year?
Yes, this just started. In fact, their people were all let go, I believe, I think June 30th was the last of their investigative people worked.
Are you monitoring, or will you be monitoring the staff impact of the increased referrals?
Oh, yes.
We wouldn't know about that.
Yes, yeah. If we see a huge uptick in complaints that we would have to open, I think we may have to make a decision, do we need another person? Because we're actually down 3 investigative positions now.
But even beyond the ones where you open investigations, you've indicated you're going to be doing more detailed letters to perhaps, and I think appropriately so, advise people as to the commission not having jurisdiction, or where they might look for relief or to forward their question in terms of what amount of staff time review and how will this impact in terms of administrative responsibilities with this new influx of responsibility.
That pretty much will fall on Brian and me. I think we can handle that. With a combination of a form letter and customizing it a little bit with some personal information, I think we can handle that.
And I think we should track, and everyone has said that, how many additional more would get.
Yeah, we will watch that. We'll be able to tell which ones are coming from the Auditor General as opposed to what comes in on our complaint form.
Yeah, even if we don't have jurisdiction, you just write letters, I would like to know the volume of what you're getting.
Okay.
Sure. I agree.
Okay.
We could discuss, let's discuss this meeting in October.
Okay. Yeah, we should have some kind of an idea
You should
what
have a
might start
count,
coming
huh?
in within almost 3 months away. We should know something more.
Maybe we ought to ask them to discontinue their tip line. I mean, if they're not gonna handle the cases, why do they
Yeah,
even
why?
have a tip line just to send the cases to us? I mean, maybe we need to talk to the Auditor General and say, you know, if you're not doing anything with it, don't just dump it on us.
That's a good point.
Yeah, good.
Next area is area of training. Brian and I did a brief training session with the Office of Chief Counsel and Administration at the Turnpike Commission on July 2nd. They, as a result of the problems that they've had down there, they want to re-educate their employees and their commissioners on the provisions of the Ethics Act. So the Chief Counsel's office invited us to come down to do a brief session last week with staff, and on the 16th of this month, Brian and I will be going back to do a presentation to the commissioners and the CEO of the Turnpike Commission. And they really want us to focus on the gifts, transportation, lodging, and hospitality, as well as the restricted activities section of the Act. And that's the first time that that's ever
I was
occurred.
just gonna
in
say,
the
that has to be-
They've ever asked us to come down.
The horse is out of the barn.
Exactly.
Yeah, yeah. Any more on education?
Yes, and I reached out to the State Association of Township Supervisors, because that's the group, I guess, the local government group that we're most familiar with. And most of their counties have a fall and spring association meeting where they'll get most of their townships, and that's probably where they get the most activity. I reached out to them and asked them either to give me a list of when the various local groups will be having their conferences, and they didn't provide me with a list, but they circulated it out there that we would be available to go put on training sessions at these local county groups. And I received, just last week, the first one came in. It was in Cambria County. It wasn't really one where it was a more desired area. We wanted to really do more northern counties because we don't get up there all that often. So I'm going to get back in touch with PSATs and see if they've had any feedback from the northern counties. But we will be going out to Cambria County in October.
Remember, we talked about training and education, especially in the hinterlands, so that's a good start.
Yes, yeah, it is. I really think it is. PSAT seemed very receptive to us doing that. I don't know anyone over at the Boroughs Association, but I'm going to give them a call too to see if there's anything I can work out with any of those groups.
Yeah, they have conferences all the time.
All the time, yeah.
Other
that's-
counties, boroughs.
Right. and to the extent you can, we should participate.
Yes, yeah, we will.
That's part of this education we talked about earlier.
Have the constables ever asked?
No, in fact, we've done quite a bit of work with the constables, putting on training when Cynthia Lynch was still here as the administrative officer. It's just been nonstop with them, but they just, I don't know if it's the guys who are serving or what the problem is, but it's just, they're not hearing the message. The other item is our vehicles. We had what we thought was a pretty nice sweetheart deal with DGS for at least half of our fleet. We were only paying $86 a month to rent cars. And any car that was more than 5 years old, the lease rate dropped to $86 a month. Well, I think General Services got wise to that, and they weren't making any money on the deal. So we got a notice at the end of May that all of our 2006 cars were getting pulled and being replaced with 2013 models. So there's a big jump in rental price. We're going from $86 a month to $389 a month for 2 of the 4 cars that we have. So that would, they're telling us that, well, because we will have less repairs that we will be responsible for, and the newer cars are supposedly much more fuel efficient. We picked the lowest, the cheapest car that they had. The rate went from $389 a month to $519 a month. So we took the smallest compact car that DGS offered. But I just want to let the commission know that that is another little thing probably going to, that will impact the budget. For
Did
this
you
year.
reflect that in the budget?
Yeah, that is reflected in there.
And those 4 vehicles are assigned to the investigators?
Yes, the 2 are in Pittsburgh and 2 are here.
2 are here.
And the last thing would be the budget, which we primarily talked about yesterday. Any extra funds that we have left over from past fiscal year and going forward, what we might have left over this year, but with the budget increase, that we want to develop a webinar training program that any public official could click on the website and get, if it's an issue of a 3A issue or a reporting issue on statement of financial interest, that there could be some specific information. And Brian and I, we're going to request Robin and Martin's help to try to put together something and get that out in the near future. That may take a little while to develop it.
And you were going to report, where are we on the financial statement filing online?
Yes, that actually is actually going pretty well. We did have a meeting with a Laserfiche company, the company that does our Laserfiche for us now for all of our online information. And it actually looked pretty promising. Robin was in attendance and Brian was there, and it looked pretty well. We did get the first estimate, which I provided to the commissioners yesterday, that I think it's a little bit low because they only provided for 16 hours of training, and also the training, that would also include any changes they would have to make. I think that's low. I think it probably could be double that. But still, with that, with purchasing new servers, we're still probably going to be less than $25,000 to implement that, and that will be reflected in the budget as well.
You and I talked, we referred to it as a we want to first start as a pilot. You want to
Yes.
comment on that?
Yeah, the pilot, what we thought we would try to do, and it's similar, I guess, to that Senate Bill 899 that's hanging around, that was introduced to require the commission to have online filing available for members of the General Assembly. And we thought we would try to do everyone in Harrisburg, everyone at least who's stationed in Harrisburg initially. And that would include the General Assembly as well as the Auditor General, Treasury, and the Governor's Office. Although the Governor's Office does have online filing now, but we would like to try to get that tied in with what we do. And we would, if, we're optimistic, but we think we might be able to do it for the May 1, 2014 filing.
That's your goal.
That's our goal.
And just as kind of a future goal, we talked about perhaps at some point, you could do it for everyone, local, state, everybody, which would require some legislative amendments to the Ethics Act, but it's kind of the way the world is going, electronic filing.
Yeah. as we discussed, and as we talked, when we went over and talked to the appropriations people, we told them about this, so this should be a high priority.
Yes, I think that might be why we got some of the budget
It
increase.
is why you got some.
Right. So, let's make that our goal by next May, that we have that available, if we can, by May 1st for the
Yeah.
filing.
Yeah, Sean, our IT guys, are
He's
doing
right here.
a lot of work on that.
Yeah. Sean, is that gonna be doable?
I think so, yes.
Okay, yeah, let's make that happen, because that should be a high priority in this age of technology. If you recall, during the interview process, every one of those candidates talked about that damn form that they required that we fill out. So, anyone have any questions of Rob or Robin? Okay, good job, both of you. All right, now, yesterday, we had a general discussion about the requirement of the budget bill that was passed, that we pass a resolution signed by all commissioners to,
Allocate.
pardon?
Allocate, that's the
Allocate.
budget word.
To allocate our budget, and we discussed that. This morning you've received a copy of the proposed resolution. Let's take a minute to look at it. We had made some changes. Oh yeah, there it is, the attached 2,000 word. Point one was the new one, right?
Well, there's actually new language at the end of both point one and point two, which would note that the commission might at some point alter or amend the allocation.
Oh, yeah, and consultation. Yeah, right, okay.
I'll make a motion to approve the resolution.
Okay, motion to adopt the resolution that we received this morning, which was revised from yesterday. Is there a second? Second by Commissioner Nick. Any questions or comments? Everyone understands why we need to do this. It was required in the budget passed bill, and we have to send this resolution plus the attachment to the budget office.
Yeah, the attachment will go along with this
That's what,
that we had.
Yes.
Oh, yes.
Yes.
that's what we agreed yesterday.
Okay.
Any other questions or comments? If not, all those in favor of the resolution you received this morning, say aye.
Aye.
Any opposed? Okay, the resolution is adopted. Council, we will be required to sign this before we leave, so
Right.
don't anyone leave without seeing Robin for the official signature for the resolution. Okay. This time, is there anyone in the audience that wishes to address the commission under the public comment section of our agenda? Mr. McNutt.
Thank you, Chairman Bolger, Commissioners. I've been involved, I guess, around the Ethics Commission since the time of its creation, and I've got to tell you that today's meeting, and I certainly don't come to all your gatherings, so many of you know 9 o'clock in the morning is not my favorite time, but I came to this meeting twice. It's my sense is that the commission is turning the page. There seems to be a new spirit of ease, of conversation among the commissioners. I particularly wanted to speak because of the questions that undoubtedly the budgetary language raised, and wanted to make it clear that that is not a reflection on the current staff arrangement, but really is a reaction to what was felt was an exceedingly closed operation in the past. You seem to be off onto, as I said, more, what appears to be more collegial, more informed roles. I think that the staff benefits when the commissioners have a general sense, not an inappropriate knowledge, but a general knowledge of what is going on and can involve themselves in that. I think the prior regime is speaking. But in any case, I basically wanted to just say, offer a commendation. I was, as I mentioned, around when the Ethics Act was passed and when it was substantially revised the one or two times that occurred. And what I hear today, I think all the decisions are meet McNett's rule of common sense. Now, what many people would say that there is no, that's an oxymoron. But there were sound decisions. There did not seem to be tension in them, and moving back to a construction of the interpretation of the Ethics Act that is consistent with what you would believe the intention of the members were in 1978 and the other relevant years, I think is important. I think there was some tendency to supplant actual legislative intent with perceived legislative intent, and where the record is clear as to intent, there shouldn't be a dispute, and the test should really be going forward on the law. If the language is ambiguous, what do you think they meant? What would they have likely meant when they were putting this together? And when you've got one hand from the time, I think, if I remember, Commissioner Colafella, you were in service at that time, but reflect on what members would have believed that they were writing. This is not constitutional law, this is not foundational. This is a statute, and we want to, on the purposes to administer the statutory intent, legislative intent. In some cases, that may yield less results than one's own moral compass might suggest is appropriate, but the real test should be the legislative intent, and I think you're well positioned to try to reach to that. There's no one person is the font of that. I'm not the keeper of it. I sometimes try to get away with that. It generally doesn't work. But to try to determine the collective wisdom of legislatures, they put the statute together. And as I said, I think you're off to what I would refer to as a kind of a fresh start. And that's, and that most importantly, the change in the budgetary language. Well, I think maybe certainly the increase in funds were reflective in part on the General Assembly's willingness to give the commission treat it as a fresh start, and not intended to be a commentary on where the staffing is now. It was on prior operations. I apologize for taking a few minutes to sermonize the commission, but I appreciate the opportunity and value your service. Thank you.
Thank you.
Very much.
Thank you. Mr. McNack, you will know that yesterday we discussed that it's time for a new direction and a new culture, and I think we've started that journey.
And if I guess this would be
Is there anyone else that has anything for the public comment section? Any commissioners have anything? Next meeting, as you've already been advised, has been scheduled. And hearing no other questions or comments, I would entertain a motion to adjourn. Motion to adjourn has been approved. Thank you all very much.